Hello, and welcome to Sounds Fair to Me, the copyright game show, presented to you by the UCLA Library. What we're going to do is play one song that's protected by copyright, and then a second song which has been accused of infringing the copyright of that first song. We will have our studio audience give their response to the questions. We'll tabulate the results, and you can see for yourself what the correct answer was. And then we will toss it over to the expert panel for review and discussion. So, we have an amazing panel of experts here today. Robert Fink, he's currently the chair of the UCLA Herb Alpert School of Music's minor in the music industry. He was a visiting professor at Yale, taught at the Eastman School of Music at the University of Rochester, and was a fellow at the Stanford Humanities Center. Professor Fink's UCLA lecture course on the history and practice of electronic dance music was the first of its kind at a major university. It was named the best college pop music class of 2002 by Spin magazine. He also teaches on Motown and soul, history of rock and roll, and pop music and politics. Professor Fink also has professional experience as a consulting musicological expert in copyright litigation, including informal consultation, formal reports, and legal depositions. Let's give it up for Robert Fink. Next, we have Judith Finell. Judith is a musicologist and the president of Judith Finell Music Services, Inc., a music consulting firm in New York and Los Angeles. Most recently, Ms. Finell was the testifying expert for the Marvin Gaye family in the Blurred Lines case in federal court. She has testified in many other notable copyright infringement trials over the past 20 years. She regularly advises HBO, Lionsgate, Warner, Disney, and Sony Pictures on musical works for their commercials, films, and television series. Ms. Finell was the commencement speaker at the 2018 UCLA School of Music commencement and will be featured in the upcoming NBC Universal documentary, The Universality of Music. She has been widely featured on musical topics on NPR, the BBC, the New York Times, and Billboard. Ms. Finell is on the musicology faculty of UCLA, where she is teaching a course called Forensic Musicology, the first of its kind in the country. Ms. Finell holds an MA in musicology from the University of California, Berkeley, and a BA from UCLA in piano performance. She has written numerous articles and a book in the area of contemporary music and copyright infringement, on the board of the Copyright Society of the USA, and has appeared as a guest lecturer at the law schools of Harvard University, UCLA, Stanford, Columbia, Vanderbilt, George Washington, and NYU. Let's welcome Judith Finell. And finally, he received an A.B. with distinction and honors in 1977 from Stanford University and his J.D. in 1980 from Yale Law School, where he served as the editor of the Yale Law Journal. Since 1985, David Nimmer has authored and updated Nimmer on Copyright, the standard reference treatise in the field, first published in 1963 by his late father, Professor Melville B. Nimmer. The U.S. Supreme Court has cited Nimmer on Copyright on numerous occasions, and as has every federal appellate court, countless district and state courts, as well as courts confronting copyright cases in countries across the globe. He is of counsel to Irell and Manella LLP in Los Angeles. He serves as professor from practice at the UCLA School of Law. He's a distinguished scholar at the Berkeley Center for Law and Technology. He has twice served as co-counsel representing clients before the U.S. Supreme Court. He gave congressional testimony at the invitation of the House Judiciary Committee in 2014 on behalf of the U.S. Telephone Association in 1997 and on behalf of the National Association of Broadcasters in 1992. Among his many accolades, Professor Nimmer was named one of the 25 most influential people in IP by the American Lawyer. And he was also named the 2018 Copyright Lawyer of the Year by the Best Lawyers in America. Everyone, please welcome David Nimmer. So, we will be taking our panel of experts through a series of questions that you will be giving your answers to as well. But we need to first catch you up on the basics of copyright law as quickly as we can. So in 10 minutes' time, prepared, you'll be completely up to speed. Copyright is brought to you by the Constitution. That's right, there is language specifically in the Constitution calling upon Congress to create a law to protect the progress of, I'm saying it wrong.
Progress of science and the useful arts.
There you go. Thank you, Mr. Expert. Copyright is actually a bundle of rights, not just a simple right, but a bundle of rights that can be used in a variety of ways to reproduce the copyright work in copies, to prepare derivative works, to distribute copies to the public by sale or other transfer of ownership, or by rental, lease, or lending, to perform the copyrighted work publicly, or to display the copyrighted work publicly. And this has boiled it down a little bit, but these are the basic framework of the bundle of rights and copyrights. And the term of copyright has extended quite a lot over the years as copyright has evolved. And currently, for any works produced in the US since 1978, for works by an individual author, the copyright term lasts for the life of the author plus 70 years. And for corporate works, copyright lasts for 95 years from publication or 120 years from creation, whichever expires first. An important exception, and there are many exceptions to these basics of copyright, is the fair use exception. And right now we're going through Fair Use Week here at UCLA and across the country, where we try to put on fun events to make you understand fair use better. This is an important exception to copyright that is useful in all kinds of situations. There are many specific exceptions for classroom uses or for library uses, but fair use can be used in a variety of settings for purposes such as, but not limited to, criticism, comment, news reporting, teaching, scholarship, or research. And when you employ fair use, it's important to remember it's a right. It's not as if you're breaking the law, but it's okay. Because you are staying within the bounds of fair use, you're exercising an important right that you have within US law. It's the one thing that allows copyright to coexist with the First Amendment effectively. When judges consider whether what you have done with a copyrighted work is fair use, they go through these four factors: the purpose and character of the use, the nature of the copyrighted work that was used, the quantity and quality of the work taken, and the impact of the use on the potential market value of the original work. These are four factors that have been considered in fair use cases for well over 100 years, but they were baked into the law in 1976. Standards have continued to evolve since 1976 to include not only these factors, but judges often bring in other factors as well. But these are certainly the ones that hinge most of the arguments around fair use. Very important, by the way, just to consider jurisprudence when you are reviewing music and copyright in particular. While the Copyright Act from '76 governs copyright, it doesn't cover every nuance of how we understand how copyright works, particularly within music. And so that's why it's going to be fun for us and educational to go through some music cases today and see how it works in front of a judge to rationalize some of these decisions. Some of the recurring factors that come up in music copyright infringement cases are determining the substantial similarity of musical components, that considering whether reasonable exposure has happened to the original work for someone to actually have infringed upon it. And this threshold of de minimis non curat lex, which is actually often referred to as de minimis, which translates roughly to the law does not concern itself with trifles. So if there's such a small use of something that it's not even worth being bothered with. Have I characterized that correctly? Everybody turns to Nimmer. Did we? Yeah.
3 is often viewed as just an application of 1. If it's substantially similar, it's infringing. If it's not substantial, then it's de minimis, so it's not infringing. There's a different use of the phrase de minimis non curat lex to mean, oh, it's so minor. For instance, you're at a restaurant and you're at your table and you're singing happy birthday to you. It might be viewed to the 3 people at your table. It could be viewed as a public performance, but it's so minor, it's such a trifle. That last application Judge Laval spoke about once, but frankly, it doesn't have any content. We don't know what is so minimal, so trifling as to not concern itself, as the law does not concern it. So I would say that 3 is just the obverse of one.
Okay. And again, we're just giving you a tight summation here. We can't explain it all to you now. If you don't understand parts of this, we can hook you up with resources that you can understand these things better. Certainly one of the recurring things in music is sampling and copyright infringement. There have been a couple of harsh early rulings that we'll talk about, but then jurisprudence has further evolved since then, and sampling is somewhat more accessible these days than it was after those first cases. We'll also be talking about a new edition, the latest revision of the copyright law, which is called the Music Modernization Act. It passed in late 2018. And it does three things. It creates a new statutory music licensing regime. It provides royalties to producers of sound recordings. But those two aspects are still actually, while they're part of the law, they haven't been fully enacted. There are teams that are still coming together to actually put together the policies to enact those. But the federal protections for pre-1972 sound recordings are really critical. And we have an article that's up at the front, if you grabbed all the handouts, written by Eric Harbison. It covers those aspects pretty well, and there might be a pop quiz on that later today, perhaps. So if you don't get those right, it's because you didn't do your homework and read the handouts. The Music Modernization Act, it actually includes the first reduction of term of protection for a class of works since the 76 copyright law was enacted. It brings key exceptions of federal copyright law into effect for these pre-72 recordings, because prior to that, they were only covered by state laws, which varied widely, and those don't always include the important exceptions like fair use. And it allows for substantial non-commercial use of these works, particularly helpful to us in a non-commercial setting. So research, scholarship can really go to amazing places with those recordings now. Okay, so again, we'll play the original song. Then we'll play the song accused of infringing that original. And then you decide if it infringes. All right, ready? Here's the first case. There's the original recording in the 1960s of He's So Fine by a group called the Chiffons. Matt, take it away.
He's so fine. She were mine. Handsome boy over there. One with a wavy hair. I don't know how I'm gonna do it, but I'm trying to make mine. The envy of others, just a matter of time. He's a soft-spoken guy.
That's good. Okay, and so the song that's accused of infringing it is My Sweet Lord by George Harrison. Came out in the early 70s.
My sweet Lord, my Lord, my Lord.
Is this an infringement? Does this infringe upon He's So Fine? Okay. So we have 9 people say it's an infringement, 8 people say it's not, and 3 people are still not sure. So we'll turn it over to the experts. Let's start with Judith.
Well, so in each song, one of the jobs of the musicologist is to weigh the quality and quantity of material that's similar or dissimilar. So I say in each song you have what you would consider the hook of the song, meaning the lyrics, for example, that go with the title. He's so fine, my sweet Lord. They're not always with the title lyrics, but in this case they are. And when you analyze the melody that is connected with those lyrics and transpose them into the same key, you'll find that they are the same 3 pitches. Now, that's a very short melody, but all 3 are lined up pretty well. There are other areas of the music that also resemble. So I'd say it's definitely on the substantial similarity side of things.
Robert?
Yeah, no, I would agree. And we didn't actually go all the way through George Harrison's song, but the fact that both of them go da 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 dee da 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 dee da da. I really want to know you. There's not just the opening few notes, but it continues, and there's another spot where there's quite a long chunk of sort of the climax of the tune, which is pretty much note for note.
Okay, David?
Yes, this is infringement. When I was exposed to this case for the first time, my initial reaction was, what the heck? Because I'd heard the Chiffons song 3 million times in my childhood, and I'd heard the George Harrison song 2 million times, and they were in completely different mental boxes, so I did not understand it at all. Then I saw the sheet music, and I saw that they're almost identical, and so I subscribed to the jury verdict. There are two interesting things about this case that I want to mention. One is that the judge developed the notion of unconscious copying as a sop to the ex-Beatle to say, no, certainly you, Mr. Harrison, did not do anything wrong, but you unconsciously copied something that was a very famous song and was in the ether. And the second part of it, is, which I love every case as a kind of story, a battle. So I read decisions to see what's the human element. In this case, George Harrison had a falling out with his manager while the case was pending. So by the time the case was presented to the jury, which issued a $1.1 million judgment against George Harrison, his manager owned the cause of action. So his ex-manager earned the $1.1 million. George Harrison turned around and sued his ex-manager for breach of fiduciary duty and won a verdict against him of $1.1 million. So life is good in the end.
Can I just point out that the Chiffons aren't anywhere in that story?
Correct.
So there's a kind of moral world that is easy to think about when you're, easy to forget about, that it may seem to be George Harrison, famous Beatle, against, 4 black women, but in fact, the battle, who actually owned that copyright, they didn't. They didn't see a penny, and wouldn't have under any circumstances.
And P.S. George Harrison's next song was literally titled "This Song Is Mine,"
which sets us up for Biz Markie later.
I'm planning on that.
Okay, so we call this one Fogerty versus Fogerty, but the actual court case is Fantasy Records versus John Fogerty. It involves a song he recorded when he was in Creedence Clearwater Revival called Run Through the Jungle. Matt? Okay, and so years later, that song, by the way, the copyright was transferred to Fantasy Records as part of his deal with CCR. So Fogerty didn't own the song anymore, the copyright. Then he did a solo project years later and came up with this song, Old Man Down the Road. Okay, look at that. We have 17 that say it doesn't infringe, and I think that's just on principle alone. But 7 do. 7 believe it does infringe. So let's throw it to the experts. Judith?
Well, obviously he had access to the song. That wasn't an issue. I never have analyzed these two, but I did hear a melodic contour that they shared. I don't think it was note for note. It wasn't as blatant as the prior two that we compared to, but I'd say it would definitely bear transcription and a certain amount of musical analysis to determine how close it is. I don't think it's 100%. There have been other cases where Madonna got sued by Madonna and others because, and I think Mariah Carey also. So there have been several cases in which the artist moved from one publisher to another, and there was this feeling that he or she, infringed another song by him or her. So it's not the only time.
Well, yeah, so I guess we've established you can self-plagiarize, right? So I don't think it's logically impossible to make this case. To me, this brings up an issue that probably will come up again, which is the question of sort of what sometimes is called prior art or common coin, right? That to defend against that, you would probably say, well, there are zillions of songs which use contours that are as close to each other as the contours of those songs. We're talking about very basic blues gestures and licks. I think there'd be to my mind, a pretty high bar of showing exact similarity to take you out of the sense that, yes, those songs sound like each other, but to a musicologist who knows music history, you can call up dozens, if not hundreds of songs which sound basically like those two.
David?
I agree that this is not copyright infringement. So once again, the court got it right. And once again, I'd like to offer two behind-the-scenes comments about it. Fantasy is an organization that was purchased by Saul Zaentz, the producer of The English Patient. He had been very involved with John Fogerty during the years. They had a huge falling out. What else is new? Fogerty put out a song called Zaentz Can't Dance. And this lawsuit then became a grudge match. It went to the US Supreme Court, not on the issue of copyright infringement, on the issue of award of attorney's fees. Even though John Fogerty won, he could not recover his attorney's fees because the rule at the time in certain circuits was if you're a prevailing plaintiff, you get your fees, but if you're a prevailing defendant, you're lucky you got off, so you don't get your fees. Other circuits had a different point of view. Went up to the US Supreme Court. The US Supreme Court reversed and said, should be even-handed. You get your fees either way. Then the case was remanded, and John Fogerty won the largest amount of fees that was ever awarded in a copyright case to that date. And the reason I find it so noteworthy is because I know Fogerty's lawyer, Ken Seidel, used to be a colleague of mine. And some years after the Supreme Court case, I picked up the legal paper to see a new case had been filed, Fogerty versus Seidel, suing his lawyer for malpractice after he won the case in the US Supreme Court and got the largest award of attorney's fees ever.
John Fogerty, not a nice man.
Okay, that's enough on John Fogerty. Now, moving on to the classic Pretty Woman case. That's enough. It pretty much repeats from there. And now the Two Live Crew song called Pretty Woman that came out in the 1980s. Okay, that's enough.
No, it's not enough. It's not enough. No,
Oh, keep playing.
You have to hear the whole thing.
Okay.
You know you're a hip hop fan.
I didn't write this version.
That's enough.
That's enough. Okay, wow, split decision. Interesting. So, 11 feel that it is an infringement. 12 think that it's not an infringement.
Because it's a trick question.
I guess it is a trick question a little bit. So, but this is a landmark case. So, let's start with Judith again.
Thank you. So this is an unusual case because it's really a parody. I mean, at least that was what was argued. So the Two Live Crew, clearly, in order to make a parody and make something, comment on something else and create some humor about it, you have to embed in your second work something from the first work, right? So that was the art form they were saying that they had expressed themselves with. So the fact that they used part of the lyrics, part of the hook, etc., from the Orbison song is part of how they were expressing their song. That being said, the job of the musicologist would be to analyze it and determine what elements and characteristics, musically speaking, are the same. So, I mean, just listening to it, you've got the guitar riff, which is an arpeggiated riff that you'd find throughout the literature. But the first job is to determine similarities and differences before you think about the rest of the literature, I think. And then you've got, the hook, the lyrics, Pretty Woman, okay? That's the hook of the song. And they aren't the same melody, though, because the other song is mostly spoken or rapped with a kind of a tonal, but more spoken, not sung as broadly. There's also a distinctive part of Orbison, and I was curious if that's why Professor Nimmer suggested stretching out the Two Live Crew part, because he makes this growl, and it's really distinctive. But I'm not sure if it was there in the part. I didn't hear it.
Yeah, correct. I was not there. Yeah,
Oh, okay.
we didn't
But
hear it. Yeah.
that's my favorite point of the song. That's him. If they had done that, then it probably would have been a sound-alike case. If they had done it at his particular low pitch and everything. Anyway, and there are other elements there. But what has been added is the other thing to think about. So in the new song, you've got the record scratch. It's in a hip hop. Its genre is not very pertinent in a way. But I'd still say they have added elements that have to do more with hip hop and less like a country western or wherever you would place Orbison in the literature. So that's what I say.
Thank you. Robert.
No, there's really not much more to say from a musicological perspective. I think the issues at play in this case aren't really musicological, right? A musicologist will end up sort of recognizing the amount of similar. I mean, didn't they ask for permission?
They asked for permission.
So they
came back
wasn't-
and said no.
Yes.
And then the next thing they know, they put out as clean as they wanted.
Right. So this becomes about fair use, right? And then the kind of sense that is there some fair, First Amendment kind of right, even if the owner of the property does not want you, the owner of the building doesn't want you to graffiti on it. Do you have a First Amendment right to express yourself? That's sort of the kind of thing. This is as opposed to stealing something. If you're thinking about those kind of metaphors from the real world of real property. So it turns out to be how much control do the people who control the copyrights have over people's expression? And I don't know if you want to pick up on that.
Sure. Well, the point you make is important because before this case, it was unclear whether asking for permission and then going ahead in the face of a refusal made it unfair. The Supreme Court in this case was very clear. That does not make it unfair. There are many reasons you would ask for permission, for instance, to reduce the cost of potential litigation. But if it's fair, it's fair. The fact that you asked for it and were refused means that the copyright owner was being unfair in this case. So it does not count against fair use. The part about this case that I find so brilliant was the lawyering that got Luther Campbell, a rapper, to submit a declaration in which he said, my intent in writing this song, in which he says, that hair, it ain't legit because you look like Cousin It, was to expose the soft underbelly of prostitution. This pretty woman, no one could look so fine, is a streetwalker in Texas, and she looks very glamorous. But I, in speaking my truth, I'm going to show how the seamy side of life. Now, I have no idea whether any of that actually figured into his cogitation when he was writing the song. But as it was presented to the courts, it was brilliant, and it attracted a unanimous Supreme Court reversal of the Sixth Circuit judgment below, so it upheld fair use.
Yep, and it's a pretty seminal case, right?
Oh, absolutely.
Yeah.
It's huge, yeah. In fact, this is the last time the Supreme Court has addressed fair use on 4 occasions, and this is the last time, so this is still the governing case from, I think, 1996.
Okay, so we gotta move on. Now we have a song by Gilbert O'Sullivan called Alone Again Naturally. Matthew, take it away.
I promised myself to treat myself and visit a nearby town, climbing to the top, throw myself up in an effort to make clear to whoever what it's like when you're shattered.
Keep going. Sorry.
It's like when you're shattered, left standing in the lurch at a church where people saying, my God, that stuff she stood in my no point in us remaining. May as well go on as I did on my own, alone again, naturally.
Okay, we can stop it there. That's probably the most important phrase in the song. Okay, so now the Biz Markie version, which came out quite a bit later.
I was on my way to 125th. I saw the death bench, yo, that's my man Cliff. As I flagged him down, he pulled to the side. At this moment, I had to swallow my pride. Cause usually I wouldn't ask for a lift, but it was cold enough and my legs were stiff. He said, hey, Biz, what you want a ride? I said, hell yeah. He said, I can't cause my girl's inside. So he jetted off, leaving 2 tracks. Not at one time did homeboy look back. It took me an hour to get where I was going, and the time it all off. It had to start showing. My sneakers was old and my coat was thin, but my determination kept me going within. I had nobody to help me, as you can see. I'm alone again, naturally. Alone again, naturally.
Okay, that's enough. Okay, we've got 15 people that say it's infringement, 8 that say it's not infringement. So, experts, take it away, Judith.
Oh, thank you. So this is a great case because this was when hip hop was coming into the music industry, okay? And there hadn't, as far as I'm aware, there hadn't been any cases, but you had things going on with the Beastie Boys and everybody else at that time. And I believe that Biz Markie signed something with Atlantic Records claiming there was no other material in his song other than his own or something. I don't know. I mean, I don't deal with contracts, so I better watch out with this panel. But anyway, I think that the record company was kind of shocked when they found out that actually something had been sampled, because this was new, but hip hop wasn't a big seller yet in the industry, and the industry hadn't and the courts hadn't caught up to this method of lifting from one recording, from a master recording, and putting it into another recording, especially when the artist asked the owners of the O'Sullivan estate, because he was no longer living, if they could do something like that, and they were told no. And then here it is. So it's pretty blatant, but it was a huge case, and the judge actually, I remember this, reading Judge Duffy's decision, at the top, in very big, bold letters, thou shalt not steal, as, one learns, and I believe like he was seeing it as you'd see any physical property, in the sense that I don't think he really talked about the music copyright laws as much as the act of stealing. And all of a sudden, it felt like overnight, but it was over a period of time, that licensing businesses started up to license samples, because it was being done all over the place. You'd go to a panel and a producer who made hip hop would say, the way I make my records is I go into the studio with all these old LPs and I just do needle drops here and there, and that's how I make my new recording. And you could see like people's faces turning white in the audience who worked for ASCAP and other places. So I'd say it's pretty close to musically. You've got the keyboard portion that supports the singer or the rapper, and you've got also the words and melodic connection.
Two things I would say about this, which are more kind of cultural points. If you go back and read that opinion and the commentary around it, I'm here to basically I'm comfortable saying it's straight up racist. So the whatever Biz Markie is doing is considered to be completely not music. He's an idiot. He is, in a sense, some kind of desecrator. So this idea that in this case he was going to be referred for prosecution as a criminal. So I mean, it's actually quite distasteful. On the musicological side, we weren't really talking. I mean, probably one of the things that pushed it over the edge was the fact that he sang the hook, right? But I just want to stand up for Biz Markie. Right? I think that what was happening there was a moment where there were many early hip hop songs. All he would have had to do would have been to get a piano player and a drummer and a bass player to perform the piano, the groove, like this that he looped, and then it would have been the same as for instance, the infamous Rapper's Delight, right, where they performed the song, what is it, by Chic, Good Times, right? Because then you have a performance, right? But in this case, if you sample it, then it's a whole different thing. And I think this is the first encounter with what sampling was. But I'm saying it was a perfectly logical way to make a rap song in those days. And people had done it over and over again. But it's hugely different legally, it seems, if you sample it rather than hire musicians to perform it. You get two completely different sort of situations.
Yeah, embroidering on those comments. I agree with the first three cases, the way they were decided. This case was decided for the plaintiff, and I radically disagree with this case. Now, in fairness to Judge Duffy, he did not have the benefit of the Campbell Pretty Woman case because that was not handed down until 2 years later. Judge Duffy adopted the logic. His logic in the case was, they asked for permission, it was denied. What could be less fair than that? So he denied fair use. Now, 2 years later, the Supreme Court exploded that notion, so the whole basis for the opinion went away. But the opinion was so over the top, as Judith said, by beginning, thou shalt not steal has been a catchword of civilization. And then by referring him for prosecution to the U.S. Attorney, which never happens, and by the way, it did not happen in this case. The U.S. Attorney did not accept that ridiculous invitation. It was just completely over the top. Life is path dependent, given that this one of the first sampling cases presented, and then another case, everyone drew the conclusion, oh my God, sampling even 1 second is going to cause our death, and so no more sampling without a license.
Right, and speaking of that, James Newton versus Beastie Boys. So on to the next case. It's first of all this recording by James Newton from his album called Choir. Okay, that's the entirety of what's involved in the next recording by the Beastie Boys, a song called Pass the Mic. Don't need to play much more. You heard the sound at the very start that it was pulled directly from James Newton. And that sound is in the background several more times throughout the course of the song.
Okay, but before they vote, I have to tell them what was licensed and what was not, and what this case was about. In the first case, we had the Chiffons did the sound recording, but they were not the plaintiff. It was Grand Upright Music, which owned the musical composition. So there are two different copyrights. One is the composer, and the other is the performer. In this case, James Newton was the composer of the music, and he was also the flautist who played it. The Beastie Boys took out a license. They got permission from the record company to use the sound recording. They did not get permission from the composer to use the musical composition. So the resulting case is not about the fact that the performance was used, it's about the fact that the music was used. So when you're voting on whether this was an infringement of the musical composition.
Thank you for that clarification. Very good. So let's go to the vote. Wow, so another split decision. 12 people believe it infringes. 10 people believe it does not infringe.
Can I jump? We can
Sure,
this
go
way.
ahead.
Yeah, jump.
This case has been actually discussed in the musicological scholarly literature, not the literature on copyright, but actually literature on sort of what you might call musical epistemology, like what is a composition. Because what it came down to was, and some of you may have been thinking this, that's just one note, right? It's sort of a kind of like Zen question. If you take a single note, not from a recording, because obviously, you know, the question of whether one drum hit, this we're talking about.
What is the sound of one hand clapping?
Yeah, it's the sound.
Yeah.
So, but we're talking about a composer writing a composition in a kind of abstract sense, and you take one of its notes. I mean, isn't that kind of like, oh, I took the C sharp? The argument made by the plaintiff was that there's a lot going on in that note. And in fact, Newton sort of claimed that he had a set of performance techniques, and he had, in fact, there was a whole little mini composition or phrase or melody going on inside that single flute note. And if you voted yes, it's infringing, I think you must have heard it that way. There was like all this stuff going on. My memory is that the case did not succeed. So the judge more or less said, no, it's one note. So for those of us who are interested in avant-garde music, it's a little disappointing, right? The notion of a note, a single note, which is the fundamental pitch that the flute is played, above which all this overtone stuff is happening, it's a little crude and restrictive. But, you know, on the other hand, you know, it increases the space where you could do creative remixing.
So, first of all, I've seen the score of Newton's work, and there's very little to it, but it's slightly more than one note. And he sees himself, I think, I really never discussed it with him, but he sees himself as a fairly avant-garde artist and flutist who expresses himself, you know, sort of beyond the norm, so to speak, that he's trying to be, and he is, in fact, distinctive. So, I mean, I understand his point quite a bit, and I would say the musicologist's role here would be to determine how similar it is and exactly what has been placed in the other recording, how often is it used, how central is it to each. But certainly on the listener standpoint, whether you have, you know, the fantastic training of Professor Fink or you're a lay listener, if you're on the jury, there's a subjectivity to your response to whether or not you even hear a similarity and think it's consequential. But there is more to it from the standpoint of the writer of the music. And he sees himself, Mr. Newton, Dr. Newton, I think, sees himself as the writer as well as the recording artist. The truth is that this is how the Beastie Boys made all their recordings. I was an expert on a number of their cases, and that's really, my favorite one is Yo Leroy, which I'll talk about when we talk about our favorites. But, you know, where they deliberately take the most distinctive feature, usually, out of another recording, and that's what they choose to feature in their work.
So it's fascinating for me to hear the musicological analysis. This case was presented to Judge Nora Manella, who's a very smart jurist, and she ruled in favor of the defendant because the plaintiff did not have a sufficient composition. There are many ways to lose a case. One, you can lose if there's no substantial similarity, but another way that the plaintiff to lose the case is if there's nothing copyrightable. If the thing that was copied might have been copied substantially or identically, but if it's too minimal, then there's no copyright protection in it. So that's what she ruled, and the Ninth Circuit affirmed her. And by the way the judges presented it, they called it three notes at the end of the day. I guess giving the plaintiff the benefit of everything. They said there are three notes here, of which two are the same because of the overdraft. don't remember the term. But in any event, even whether it's 2 or 3, that's not enough. That's not a small enough. That's not a big enough nugget to attract copyright protection, and therefore they lost. And I agree with the ruling.
I think it's overblowing. Overdraft is what happens on my bank account. Yeah. On a regular basis. Yeah, that's one reality of musicology.
Okay, so on to the next case. Bette Midler versus the Ford Motor Company. This is another seminal case. So let's start off with Bette's original version of a song called Do You Want to Dance? That's enough of that. And so Bette Midler was asked if they could use her song in a commercial put out by Ford for the Mercury Sable car. And she refused. So they actually recruited, I believe, one of her backup singers to do a sound-alike version of the song. And here it is now. This is how it sounded in the commercial.
Do you wanna dance and hold my hand?
Now there's a car that just asks to be driven.
You're my lover man, oh baby.
Mercury is bringing a sophisticated...
Wow.
Now, hang on. What question are you asking? Because are you asking...
This is a trick question.
Are you asking the question, was this an infringement of the music because Ford got a license for that? Or are you asking, is this an infringement of Bette Midler's sound recording, for which Ford Motor did not get a license? And by the way, this actual case did not present either of those issues, but for the sake of the exercise...
Yeah, it's a terrible trick question here. It really is. I've done a horrible thing to everybody in the audience.
Again?
This is why there are no prizes. Because I knew there would be this kind of thing.
This is a trick one because it's, in fact, there wasn't any real sort of copyright issue here.
Yeah, this was not a copyright case.
I mean, by saying Midler's original is what you said, you didn't even specify.
Yeah,
that.
you're right. I misled.
Did she write the song? I think not.
She didn't own. I don't think she owned.
No.
She did not write the song because she wasn't the composer.
And she didn't own it.
And she didn't own them. They licensed the sound recording, so this should be fine, right? If in fact,
wait.
well, I'm saying
They didn't license the sound recording. They licensed the
but they didn't need
composition.
They hired Ulla Hedwig, the backup singer, to make her
right. And the point is that
her own version. They did not sample or copy the sound recording.
So every cover band that's playing in every bar is relying on the right to do this.
Well,
you know,
this
but
was-
there's another issue which you could sue on, which I guess you want to.
Yeah, so, all right, so this is, I mean, I wasn't involved in the case, but the outcome was this, that Bette Midler has a very, very distinctive singing voice, and this arrangement of that song, which is very, very slow, breathy, you know, there's a lot of innuendo in it and all, which is what I'm sure appealed to the makers of the commercial. And that's what Bette Midler saw as her distinctive contribution to the performance of the song, and she said, no, I don't do commercials. So, I mean, then they went out and got somebody who actually made a living, not only being her backup singer, but by performing in clubs as a sound-alike to Bette Midler. I mean, like that was the person's, you know, presentation. So they really went far because most people seeing the commercial probably did think it was Bette Midler. And so she had a point, you know, but she couldn't come after them on the copyright for the composition because she didn't write it. She was just a performer.
So the legal grounds was false advertising. I think there was a
Well, it was right of publicity.
right.
Yeah.
Yeah.
And
It's a
she
tort
won
claim.
big. She won
Right.
at
Okay.
that time.
So let's quote what the statute. Let's quote what the statute says. She's not the composer, and so she does not have any rights in the composition. Now, Ford Motor Company made a sound-alike recording. They hired Ulla Hedwig, her backup singer, to do it. Here's what the copyright statute says. The exclusive right of the owners of copyright in a sound recording do not extend to the making or duplication of another sound recording that consists entirely of an independent fixation of other sounds, even though such sounds imitate or simulate those in the copyrighted sound recording. So as Robert said, it's perfectly legitimate to do your own cover version, even if you hire the backup singer. I mean, Ford could have hired the backup singer and the drummer and the recording engineer, et cetera, as long as they didn't actually duplicate, then they would be totally fine under copyright law. But what she sued for is under her right of publicity, and what a strange case it is. Right of publicity cases means you've copied my name. Well, they didn't use your name. Or you've copied my signature. You've copied my image. They didn't use your image. You copied my voice. They didn't use her voice. So she had to come up with some new theory, which was not even covered under California statutory right of publicity. She won big because the Ninth Circuit made up something that says that, well, even though it's not included in the California right of publicity statute, there's a common law right of publicity which includes, I don't know, her sound or something. So it was a very, very strange case that completely mangled every legal doctrine, but it did justice as they saw it fit in this case.
Well, can I just say, this is one of the things I work on as a musicologist, which is the notion that people have a sound. You know, it's a hugely important thing within sort of all musical performance, but probably popular music performance, maybe more than classical, that people spend huge amounts of time and energy trying to create distinctive sounds. You know, Bob Dylan's voice or Carlos Santana's guitar sound. And it's logical, in a sense, from the perspective of how pop music works, that you might think that if you could recognize that as my sound, then it was me doing it. So I understand it's probably bad law, but it sociologically makes sense within the musical community. I think more than one artist has tried to do this. They haven't all succeeded.
Let's go back to John Fogerty then. So then he certainly, Run Through the Jungle sounded very much like The Old Man Down the Road. So it was more similar than Ulla Hedwig it was to Bette Midler. Well, yeah. John Fogerty to Creedence Clearwater Revival. So should he have lost that case too?
Well, but it wasn't. We're not talking about a copyright case, right?
Well, so make it a right of publicity case.
Well, can you be accused of? Well, but remember, John Fogerty is on the same side there.
I realize that.
Yeah.
Right.
So, no, I'm just saying you can't. I mean,
right.
I'm not a lawyer,
right?
Clearly, and I wasn't saying anything. I wasn't saying that because musicians think this way, they should have the right to be compensated. But it is also true that it seems like the Fogerty case, how can you sue yourself for right of publicity? Right? I mean, Zentz, no one would think that Saul Zentz, you know, like,
good.
So
Fair
it's
enough.
not, I'm glad I passed, yeah.
Okay, let's move on to the last case we're going to cover in this way. The Blurred Lines case. So let's play the original by Marvin Gaye. Got to Give It Up. Feel free to dance to either of these songs while we're listening to them. It's quite all right. Probably enough of that one, right? Mm-hmm. And then on to Blurred Lines by Robin Thicke and Farrell and T.I.
Everybody get up.
8 of you have agreed with the trial court in this case that this is an infringement. 5 of you have disagreed. You should know that this is still on appeal, and some of the people on this panel are parties to this case in one way or another. So let's start with Judith.
So I was the expert witness on the Marvin Gaye side. So I just wanted to be clear that, just to be honest here. But so I analyzed the music. That was really my job before the trial took place. And I had the feeling that what was similar between them went beyond what you might think of genre, style, vibe, all the other words that have been used to discuss this in the press for the last 3 years since the trial. Because when I drilled down below, sort of under the hood, what I saw was similar melodic, various musical features that were the same or very, very similar between them. Not identical, but enough that I actually looked at it in depth and realized that what was similar was concrete musical elements that I called a constellation of similarities. And the reason for that word doesn't mean a basket of just kind of throw everything in the basket as a collection, but that these similar features in each song interacted and affected one another musically in a similar way. And it involved certain key words that I called word painting because the melody illustrated certain primary words that both songs had in the same way musically. There was a structural similarity where the rap comes in on blurred lines as opposed to what I call the parlando, which is a spoken section in Marvin Gaye's song that came in identically at the exact same place in the recording down to the millisecond, and it ended at the same place in the recording down to the millisecond. But we were reduced to not playing the recording in the trial. So it really was a matter of the lead sheet that was on file with the U.S. Copyright Office that was only allowed to be shown and discussed and analyzed. So we went from a constellation of 14 similarities when including the recording originally to, as the dispute progressed, down to 8 similarities that I was able to illustrate in testimony and show that out of 130 bars of blurred lines, at least one, but usually multiple elements of that constellation were in all but 2 bars. And so that's a really quick summary of how I see it.
Okay. Thank you. Robert?
Well, let me just point something out. I mean, it's a little ironic because what Professor Finell, what she accomplished in that case was completely misread by almost everybody outside of the courtroom, and maybe even in your own minds, what you thought was going on. People took this to mean that somehow groove was being copyrighted, or feel, or some sense of influence, because that was sort of, I think, if you just listen to the 2 songs and you don't do the musicological analysis at the level that she described, what you're assuming then is that they kind of feel the same. And I think a lot of bad commentary has been out there on this case. So it's useful to hear that, no, this was done in a kind of traditional way. I think we're right on this notion of a constellation of similarities is, I think, right on the cutting, somewhat controversial edge of copyright law, right? There's, certain, on appeal, there's an amicus curiae brief where a number of musicologists, some of them, who have done copyright cases, others who are just kibitzing, have as one would imagine, come up with different musicological opinions. Everybody has, in a sense, this is inherent in copyright and fair use kind of stuff, that there's no, what's it called, bright line. I mean, there's a temptation to want to draw a bright line. This is a blurred line, right? It really is. And it'll always inherently be blurred. So this 8-5 decision seems really quite correct to me in that I don't think this is a resolved issue yet. And the job of a musicologist, like any other, I think, expert witness, is to make the best case you can, and in accordance with your professional ethics, to say what you believe to be true and attempt to, let the courtroom sort of decide.
Okay, David?
When we heard Luther Campbell's Pretty Woman, there was so much in common with Roy Orbison's Oh Pretty Woman. Here, much less in common between Blurred Lines and Got to Give It Up. But I told you that the most brilliant part of that earlier case was the lawyering that had Luther Campbell give an affidavit saying, of course I copied it, and the reason was, and then he talked about the dark underbelly of prostitution. And we see the exact opposite phenomenon here. Pharrell Williams goes on TV and is asked, what's your inspiration for this song? Oh, well, we just copied Marvin Gaye. And then later on he says, well, I was drunk for 3 years and I don't know anything I said. And then he says that he composed the music. Then it turns out he doesn't read sheet music. So I'm sure I'm mangling the exact details, but it was just presented as a litigation matter in the most in the worst posture for the defendant, and then the defendant lost, and that's what happens in these cases. So in terms of the ultimate judgment, the case is still on appeal, so I'll reserve judgment, but those atmospherics are crucial in every piece of litigation.
Does everybody get the metaphor of the mystery round? Yes, you never know what you're going to get. So we're using the same Kahoot. 3 of the following songs were recently declared to be in the public domain after court challenges to the purported copyright owner's legitimacy. So which one of these songs is not yet in the public domain? Let's go right to the question. Happy Birthday to You, God Bless America, We Shall Overcome, or This Land Is Your Land. One of them is not in the public domain. Which one?
Why would you pick? I didn't read
Oh, nobody knows this one. Everybody's guessing. Obviously. So, I'll tell you, it's God Bless America. All the rest of them, through court challenges, have been pushed into the public domain because the people who purported to be the owners could not properly demonstrate that they own the copyright in one way or another. The most notable one was Happy Birthday to You. There was quite a big kerfuffle over that one, but the other 2 songs were chased after by the same group, I believe. Yeah. But God Bless America was written by Irving Berlin. That is still protected by copyright, but interestingly, the royalties from that song go to the Girls and Boy Scouts of America. Okay, so we are running out of time, but I want to do the Ask the Experts lightning round, which is simply to ask you all, what is your favorite copyright case involving music and why? So let's start with Robert.
Okay, I'm a music historian by trade, and so mine's a golden oldie. I think my favorite copyright case is Arnstein versus Porter, and that's Cole Porter, which is one of the landmark cases from, I believe, the early 40s or late 1930s, which is like a kind of screwball comedy movie from the 30s. The plaintiff was kind of, frankly, slightly loopy, kind of conspiracy theorist who sued effectively every composer, every Broadway songwriter, most of the major corporations, believed there was some conspiracy out on part of everybody in the world to steal his hit songs. He brought in a tune detective from the radio who was a kind of parody of a musicologist. The case was covered in the daily papers in New York like a kind of, Kardashian event, right? Because it involved someone like Cole Porter. So it was high drama, and as a bonus, because it was so out of control, this guy Arnstein's cases really formed the basis for disciplining copyright law and creating the framework within which musicologists work. So the pitch is, there's a book called Unfair to Genius, and I have to say it's a great read if you're interested in this kind of stuff as a kind of historical phenomenon.
I just want to add that the weirdest thing about that case is one of his theories, which should have been laughed out of court, but the Second Circuit said it seriously, is, well, maybe Cole Porter was able to copy my music because he hired people to break into my apartment to read the sheet music.
Yeah, paranoia. Yeah, it's paranoia, and sometimes it takes a kind of crazy person to make the law stronger, right?
David, what about you?
Okay, well, I guess in the context of what we're doing, the Michael Bolton case would be my favorite because it would reverse everything that we learned. But since we can't play the music, I'll go with my favorite case is the case that arose yesterday. So let's go to the screen.
Yes.
So as of yesterday, the headline is that 2 musicians generated and saved every possible memory to a hard drive, and then they abandon the copyright in it and turn it over to the public domain. So the theory is that if in 1 year a lawsuit is filed, that the defense will be, okay, what I have, my song, is exactly identical to something that's in the public domain, and therefore I cannot be culpable of copyright infringement. Now, in reality, what they've done is to accomplish, in my estimation, absolutely nothing as a legal matter, but it's great guerrilla theater, and they're getting headlines out of it, so you can't criticize them for that. But I'll tell you what the analysis would be. If in the future X composes something and is sued by the estate of Marvin Gaye or whoever it is, or Gilbert O'Sullivan, then at trial, the defendant will put in evidence, look, what I produced in 2021 is exactly identical to file 13794284866 out of 10 billion files. Is that relevant to anything in court? No, it's not relevant to anything. So therefore, I think they've accomplished nothing.
Judith?
Well, my favorite case was actually Stravinsky against Disney for the movie Fantasia, because I happened to get sort of a dream assignment. Most of what I'm asked to comment on or testify in is popular music, because that's sort of where the marketplace is and where the lawsuits and disputes occur. But one of my favorite works of all time is Rite of Spring. And so I got this call from, the Stravinsky estate and Boozy and Hawkes and all that. The Rite of Spring had been used in the movie Fantasia by Disney. And long story short, many years came after the 1930s when the movie first came out. And in 2000, a millennial celebration of the year 2000, there was a big DVD that was issued by Disney, and the Stravinsky estate went after Disney. Not because the use of sacre by itself, but because they had used the music, changed the order of the movements, eliminated some parts of it that the Disney company felt weren't squeaky clean, because the ballet has to do with sort of the sexual awakening of a young nymph or a girl or whatever. And so I just remember this quote in reading the materials. I was given actually this Stokowski score that was used in the movie, and I saw the markings and slashes through the score of parts that were eliminated. And the composer, this was a concept of moral rights. The composer went to one of the premieres in Hollywood with George Balanchine together, and he brought his score, and Balanchine, what I read anyway, was that Balanchine said, "What are you doing with that?" And Stravinsky said, "Well, I want to follow the score to my music." It was the dinosaur scene in the Fantasia. And he said, "Oh, you won't recognize your music because they've changed it so much." Anyway, that's my favorite case.
So that's our show. Thank you for playing Sounds Fair to Me. We'll see you next time.